next case is Posan, if I'm saying it right, whereas Boyer. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
Do you permit 5 minutes?
Yes.
I would like to reserve the full 5 minutes.
Okay. No problem. I will try to let you know when you're about a minute of your time left. You'll be looking at that top circle. It's going to count down from 15 to 5. I won't use the bottom, so forget about that one if you would at this point in time.
I have one other question listening to the other. At the time of filing, ABV was a minor, but now he is of age of majority. Do you object if I use his first name? Since he's no longer...
I don't think you're using first name, no. If you're saying he is now an adult, I think that protection is not as concerned. I don't know if anyone else on the panel has a concern about using the first name of this person.
First name is fine.
Thank you. The arguments are being recorded, so when you come to the podium, please introduce yourself. Please stay behind the podium because we're visually recording you, and please speak loud enough so we can hear the also know how to record what you take. And we said, if there are any other children, because I know there are some other children who were witnesses to this matter, if there are any children or minors, please refer to them by initials.
The only ones I would refer to are of the age of majority.
Okay, very good. With that, we've read your briefs and ready to proceed whenever you are.
Your Honors, Mr. Lyons, my name is David Hilkert, and I'm here on behalf of Amanda Posan, individually, and as next friend for her son Tony, who is now of the age of majority. Tony was 15 years of age and a sophomore at Barberton High School when he lost 4 digits on his dominant left hand on December 18, 2017. On behalf of Tony and Amanda, we are here a second time seeking reversal of an order granting Appellee Boyers and Barberton's High School's December 15, 2021 motions for summary judgment. This time, the order is dated May 1, 2024. And if at any time the court has questions, I invite those questions. Previously, in what I will call Posan 1, the lower court had addressed these very same summary judgment motions and had issued a very similar opinion on August 17, 2022. Amanda and Tony appealed and presented 4 assignments of error. This court in Posan 1 reversed on assignment of error number 1 and agreed that the trial court had applied the wrong definition of recklessness. The majority of the court then found the other assignments of error were premature and remanded to apply the proper definition of recklessness. In a concurring opinion, Judge Carr analyzed things differently and deemed it necessary to address assignment of error number 4 because if there was no negligence, as claimed by the trial court, then the application of the correct definition would make no difference and would be harmless error. Judge Carr, in the concurring opinion, appropriately, when reviewing the record, in our opinion, found that there were genuine issues of material fact and that the trial court should not be making findings or be requiring the appellant to convince her that they had a good case. It was a question of whether there were issues of material fact. We are now here a second time, basically on the same opinion, with the exception of the addition of 4 paragraphs that discuss, after commenting again about wanton conduct, Anderson versus Maslin, and then reissuing an opinion. In the reissued opinion, the court said it was, quote, not convinced that there was a jury question on recklessness, and thus the court finds that Boyer did not act recklessly. In doing so, the court acted as a trier of fact as opposed to seeking to determine whether or not there were genuine issues of material fact, the standard under Rule 56. Also, in assessing the school board's liability under 2744.B4, the lower court, again, not even discussing or even commenting on the concurring opinion, found again that the board employer's conduct was, quote, not so defective as to rise to the level of negligence. Again, making findings of what, if she was the trier of fact, she might or might not do.
So you're saying she was weighing the evidence in
She
her own?
absolutely was weighing the evidence. Not only that, she presented it as if there were stipulations. There were no stipulations in this case, and what happened were there were certain facts that may be deemed favorable to the appellee that were set forth, and she ignored any evidence, including expert affidavits, including the testimony of Boyer, where he admits that he violated his own policy, kind of like in the appeal you just had before you were, that was considered significant on recklessness. She ignored all of that, and she made it appear as if there had been stipulations by the parties. And in doing so, she ignored, for example, if you take a look at the record of Madison Joinder, she claims that at best for them it was he was straddling the door. He certainly wasn't paying attention to the students. And if you listen, and she makes it sound like that's the only evidence. The evidence of Madison Joinder was that he was not only not straddling, he was in the tool room and towards the classroom, and that this wasn't the first time when there were running machines that he had done this. If you took her record 60, pages 13 and 14, Alexander Schmidt, he said he wasn't in the room. He was way in the middle of the tool room. He couldn't see anything, and in fact, it took him some time to get back to the workshop when the boy lost his fingers. He wasn't even, had to hear the screaming. He wasn't even in the room.
The Pele cites cases regarding safety training and whether the student had safety training and recklessness.
This safety,
So do you think that, I mean, even if taking in a light most favorable to the opposing party and the contrary evidence you just said, how does that work in conjunction with that case law?
safety training in this case was minimal to non-existent. You take a look at the Exhibit A, or 1, Defense Exhibit 1, their quote safety training, the test he took, you can get that, you can learn that in 10 seconds. It's one page, and all you do is stick in the things. And in that safety training, unlike the one that came, that's from the home builders, they never ask you one single question, not one, about safety devices for this machine. If you take the one that's more a true safety training, they require you to list the upper and the lower guard, and if there's true safety training, they tell you, do not operate this machine without the lower guard.
So
And our expert,
that's what I was going to get to. Your contention here, I'm just trying to get this right in my head. Your contention is that it's inherently reckless if the teacher isn't in the room while a student is using an inherently dangerous machine.
60 miles an hour is 30 miles. And not only that, when you get close to it, I don't think students realize this, it's not like something else. When you get close and they have the marker, it pulls you in. So not only are you're asking students to run a machine running 60 miles an hour without a guard that pulls you in. And that's why you have experts explain just how dangerous, just how reckless what they were doing in that shop was. They make it sound like, well, I didn't know about this, I didn't know about OSHA.
So can shop class ever exist? I mean, would a teacher across the room prevent this kind of
Absolutely.
accident?
In fact, if you look at the tape, he did. When he was there supervising, if you look at the videotape when he gave the demonstration at the beginning, one student, it was actually Alex Schmidt, had his hand a little bit close, moved it back away. So absolutely he would. In fact, it's proven on the tape. And in addition, when you look at this, what they say, one reason you get, there was an expert also on the machinery itself. He was an expert on woodworking. He said that the wall was part of the PTI, the Power Tool Institute. This is a class 5, the most highest, most dangerous of power tools. The wall itself, as early as 2007, told you to put these guards on. So they say, well, the manufacturer 50 did. Well, if the Walt's the manufacturer, they're part of the power tool industry. You read that expert's affidavit, that's Les Winter, and you read also the affidavit from Bradshaw, who set up a shop just like this for Case Western and said, this machine in this condition, I would not have it in our shop.
Captain, you're running low on your rebuttal time. I didn't want to interrupt you there, but about 20 seconds left on your initial time.
Just to give that, you're also contending about the age of the machine and the condition of the machine that this teacher allowed to have in that room. It was inherently dangerous?
Yes, it wasn't
And
here.
reckless to have it in the room.
Yes, it's not, some things that are old are okay, but, for example, you wouldn't use a car without seat belts, even if it's old and even it's good for student driver. Because he's going to, student drivers, we have safety for a reason. And this has been safety, it's been OSHA for over 50 years. Yes, the machine's old, it's 70 years old, but this floating guard, it's not new. It's been in OSHA forever, and it's demanded to be there for the very reason that you don't have this specific accident where they don't have a dust collector on the machine in addition. And the kids, they know he's going to, one of the things to tell them is not to swipe dust, but they don't have a dust collector on it. He's swiping the dust. It's foreseeable. If you don't put a guard on that machine, this is the results you're going to see. And they had a better machine. I will go over it. If you read Bradshaw on recklessness, first you try to eliminate, then you substitute. You know why they didn't use the machine that this never happened with? Because of a $100 cartridge. They didn't want to make that cartridge go on the saw stop, which has the fleshy, your body is 90% water. So when you get close, unlike pulling you in, this machine does, it shuts off the blade. So because your body's got all this water in it, they had that machine. They could have used it. But that's the machine that he wouldn't allow anybody to use except with direct supervision. If you listen to the kids, when they talk about direct supervision, they knew the difference because they said with that saw stop, they did have direct supervision. So with that, I would, I accept that even at my time.
No problem. Thank you.
May it please the court, Mr. Elkert. My name is Jim Lyons. I'm here today on behalf of the appellees in this case, Mr. Boyer and the Barberton Board of Education. And we are indeed here before the court for the second time. And the court today is to apply a de novo standard of review. And on behalf of the appellees, we submit to the court that genuine issues of material fact do not exist, and that the facts, those undisputed facts, when construed most favorably in favor of the appellees, lead to the conclusion that they are indeed entitled to judgment in their favor as a matter of law. After the first remand, the court applied the correct standard under Anderson pertaining to the definition of recklessness. And that is the conscious disregard or indifference to a known or obvious risk of harm. And it's significantly greater than recklessness. the entirety of the evidence is that before these students were submitted, were allowed to use that equipment, there was significant safety standard. I believe that every student who was deposed indicated that the first several weeks, if not months, were spent reviewing the safety literature.
Counsel, let me stop you. How do we get past the fact that the court said she's not convinced? How do we get past the fact that the court said, I find? Those are not things that you should be considering. It doesn't matter whether she's convinced. It's a matter of whether there's reasonable issue of fact and whether a jury may be convinced.
The court granted summary judgment pursuant to Rule 56.
Could you repeat that?
The court granted summary judgment in favor of the appellees in favor of Rule 56. We are here before this court on a de novo standard of review. So the question before this court, are there any genuine issues of material fact?
So we should just ignore what the court said. Is that what you're saying?
I'm saying that the standard of review before this court is a de novo review.
So that's the point then. So we can just look at everything ourselves and determine that the court got it wrong. And so we shouldn't really care what the court said about convincing her or the findings.
I don't believe the court got it wrong.
I understand that. I understand that. I'm just trying to see procedurally how we handle this. That's all.
And procedurally, I agree with the first part of your question, is that you review, this court reviews any finding of summary judgment, whether it's immunity or it's a slip and fall under a de novo standard of review.
Of course, this court has also said that we're not going to act as the trial court, and we give the parties the first opportunity to make the arguments in court to determine that. So if the court applies the wrong law or applies something inappropriately, I don't even know if the de novo review still would cure the problem.
I understand the court's ruling on the first decision, but I believe in this instance, the matter was before the court pursuant to Rule 56 of the Ohio Rules of Civil Procedure, and it comes to this court undisputedly on a de novo standard of review. So I think it is incumbent upon the court to apply that standard and not remand for a reason other than that. With regard to the undisputed facts, there were also there was also a safety contract that the student and the parent had to sign. They were tested significantly on the equipment. Mr. Boyer demonstrated and observed each student operate the equipment, and the appellant himself admits that he disregarded Mr. Boyer's training. I believe that that is a significant admission on behalf of the appellant. And if you look at those undisputed facts, I don't believe that any reasonable person could come to one conclusion, and that being that there was not a conscious disregard or indifference to a known or obvious risk of harm. In fact, these facts mandate a conclusion that Mr. Boyer was concerned about safety. The only evidence they offer to the contrary is OSHA. OSHA was enacted by Congress, emergency standard in 1971. It became...
I appreciate the OSHA argument. I don't think that's the only evidence they argue. They argue that Mr. Boyer left the room. They argue that there was horseplay going on. They argue to me that there was some other safer machine they could have used rather than this particular machine when there was no supervision. So I don't think they only argue OSHA. Do you not recognize they made these other arguments regarding he left the room and those types of things?
I do not believe that those facts create a genuine issue of fact with regard to whether or not Mr. Boyer acted with a conscious disregard or indifference to a known or obvious risk. I stand by what I just said, Your Honor, and then that those facts suggest anything but that.
But nonetheless, those facts are there that the court can consider and we can consider. So those arguments were made, whether they're going to be controlling or they're going to be conclusive, that there is immunity or that there's not. Judge Stevenson was indicating that there's more that was before the court instead of just OSHA.
Certainly,
Yes, I appreciate that, thank you.
of course. But again, I do not believe that they create a genuine issue of material fact. I think the overwhelming evidence is that Mr. Boyer cared about those kids. They may suggest otherwise, but I think the fact that there was so much training, a safety contract, and as they argued in their reply brief, it's not an absolute defense, but it certainly demonstrates anything but recklessness.
So what about the machine itself? I mean, the training is one part of this, but the machine's from 1950, and the appellant here is arguing that there's indicators and evidence that it's unsafe and not up to date and safety.
Your Honor, they would have sued the manufacturer if the statute of repose was not in existence. That does not change the conclusion that there still is no material fact of a conscious disregard. He tested the machine. Had the machine been operated according to his training, it wouldn't have happened. And in fact, as I said, the appellant admitted that he disregarded that training. I believe that the first assignment of error on behalf of the appellees should be overruled. As to the second assignment of error pertaining to the board, we submit to the court that there is insufficient evidence of negligence, that the competent evidence before the court on behalf of the affidavits submitted by the appellees that do not assert legal conclusion, establish the standard of care for a high school shop teacher. And we likewise believe that, notwithstanding the Greenville decision, that the definition of utility previously adopted by the Supreme Court still stands, that the machine did in fact still have utility, notwithstanding the absence of the guard. And finally, the court did not address, and I agree, that is the case, that the reinstatement of immunity, as the court just discussed in the previous appeal, that needs to be considered. 2744.03 A3 and A5 both reinstate immunity. The standard under A3 does not have a recklessness or bad faith or malice standard. There is significant case law indicating that Mr. Boyer's use of the saw and teaching the students was within his discretion in policy making. And then under A5, the exception there is recklessness, and we have just discussed that. On behalf of the appellees, I would submit that this court affirm the correct decision of the trial court. Thank you.
Thank you. How much time did I go?
3 minutes, Mr. Hilder.
I went over, so I have 2 minutes.
Yeah, you got 3 minutes total.
I will give it 2 minutes. I would submit, first of all, with respect to the record, the affidavit, and I believe it's R58, the affidavit of Les Winter about this machine. It's not just age. DeWalt made this machine. As of 2007, it's a member of the PTI. As of 2007, it's recommending the lower guard, and one of the reasons it's recommending the lower guard is because the industry accepts OSHA. And in fact, the industry wanted this OSHA standard because some people were saying only the saw stop. So the industry wants this OSHA standard, which requires the lower guard, which they show, and you'll see in the affidavit. Now, with respect to the argument also about the training, there's the affidavit of Jason from Bradshaw, he's also an engineer, about proper training. They certainly did not do proper training. In the affidavit of Tony shows how little, again, it's R58. He had used this 1 or 2 times. He had never been told anything about the safety equipment. And finally, take a look at the affidavit or the testimony of Alex Schmidt about when they're allowed to use the saw stop. And I submit evidence of what's more important, 4 digits on your hand or a $100 cartridge.
Counsel, let me ask you, since you're running out of time, you brought to the attention of the court saying it was not convinced in making findings, and you said that was improper on summary judgment. Are you asking this court to remand for the court to look at it again? Or do you believe we can, as a de novo court on summary judgment, just make a ruling?
I believe you could make the 3 votes. I didn't go back a full time.
Thank you. The court will take the matter of advisement into a decision in due course. When that decision is released, it will be mailed to you by the clerk of court and also available on the High Supreme Court website. With that, I'd like to thank both of you for your presentations today on behalf of the court.